From the News Channel 5 Network, this is the Takacs McGinnis Elder Care Law Hour.
Welcome to Takacs McGinnis Elder Care Law Hour, where we explore the many issues that arise due to aging, disability, and unexpected illness. I'm your co-host, Tim Takacs.
And I'm Barbara McGinnis, and we're going to be talking about
healthcare.
Healthcare, but research and preventive studies.
Yeah.
Nashville's often called the healthcare capital of the South, and we do have a lot of great healthcare in Nashville. We have lots of opportunities, but we're going to pick up the conversation where we left off last time, where we were talking about how does a new diagnosis, or a chronic health condition change your estate plan.
Right.
So specifically, Tim, if someone comes to you and they're worried about their child's health care, or they're worried about their child's future care needs, their child has some sort of life-altering diagnosis, what do you do?
Well, the first thing is like we always say, is that whether that illness or disability is long-standing or whether it just suddenly occurred, anytime something like that happens, estate planning needs to change, or the person's estate planning needs to account for that.
Right.
You know, people get married, people get divorced, people go bankrupt, people have creditor problems, people get sick, all those sorts of things, and it may not affect you personally, but it could affect, and often does affect, your estate planning, because in those situations where you have a child who has maybe special needs, you know, maybe they developed, maybe they have cerebral palsy, something that they've had for a lifelong, you know, or maybe it's an accident or an illness that you had a healthy child who was 50 years old and now is not so healthy, you know, then estate planning for the parent typically needs to change, because, I mean, you know, from, you know, the many cases that we've had where parents come in and they're not so much worried about themselves. You know, they're worried that they're a 75-year-old parent taking care of a 55-year-old, you know, child with a disability or a special need. And so our estate planning always needs to account for that. So inevitably, in those kind of cases where the parent says, what is going to happen when I'm gone? Who's going to take care of my child? You know, what is that going to look like? You know, should I leave money to that child? Should I give it to, you know, his little brother and let him hold it? You know, all those sorts of things. And so that's basically that's kind of the scene setting, you know, for that kind of case.
And it's actually not uncommon for those parents to come in and say, well, I'm not going to leave any money to this child, but I'm going to leave it to their brother or sister, and I know they'll use it to take care of them. Is that really a good idea?
Almost never.
Almost never.
You know, and we all know from our long experience of doing this is that, you know, we tend to say is that if you leave something to a child and say hold it for somebody else, remember you're talking about the most unreliable people on the planet.
Well,
which, you know, it sounds wrong to say that, but at the same time, life gets in their way too.
Exactly. That's really what you mean.
And that's really what I mean, because, you know, those children almost always have good intentions, you know, but you don't know, you know, what that child's circumstances are.
Right.
You know, years and years ago, I had a case where Mama was trying, you know, she owned some property, she owned a warehouse, and she said, look, I don't need this anymore, I've got a house, I've got money, and I just want to give my warehouse to my kids. So we started having family meetings, and after the second meeting, one of the children came up to me and said, Tim, don't tell my mother, which a lawyer never wants to hear.
Yeah.
Because, you know, how do you not tell your client? You know, but she said, don't tell my mother, but my husband and I are in bankruptcy. And I'm going, oh, that's why you really don't want this warehouse, do you?
Not now.
Not now. Maybe later, or maybe there's another way that we can say maybe put it into a trust or something so that it can be protected.
Right. You
know, for that child.
And speaking of bankruptcy, I mean, there is a lot out there right now that medical bankruptcy is one of the number one, or medical costs are one of the reasons for bankruptcy.
Exactly.
And in fact, it's one of those things where Tennessee ranks very high. We're like 11th in the nation in medical bankruptcies.
Right. Yeah.
So, and that's not medical providers, that's people going bankrupt because of medical costs.
Exactly.
All right.
So, So you have people that are on, okay, so they're let's say people are calling us, you know,
Yeah.
and they have a disability and maybe they're on public benefits. Okay, so what if they get an inheritance? That's kind of like the flip side here, right?
Right, right.
You know, where you have a parent that leaves, you know, wants to leave an inheritance to a child who has a disability. But what if the child now gets an inheritance?
Right. Some long lost uncle or something leaves them money, and it's like, okay.
Oh,
so
thank you very much.
Yeah, it's like, but it depends, right?
Right.
So, are we talking about enough money that it's solved all their worries in their life? Probably not.
Yeah.
It's probably maybe token money.
Which is often is, right?
But enough to cause a disruption in their public benefits if there were not particular plans for that.
So
we can set up some special needs trusts. A person can set up their own special needs trust.
Yeah.
Parents, court, you know, we can do some things to set, if they're under the age of 65 when they inherit, right?
Yeah, right.
So that's a fairly easy and common thing that we do.
Yeah. Well, but you know, that sounds really complicated, but okay, so let's say it's a $25,000 inheritance, you know, that Uncle John leaves.
$25,000 is not that hard to spend.
Right.
You might think about spending that.
If you can spend it in
the period of time that your benefit program requires it to be spent.
Yeah. But why not just get like $100 bills and put them in an envelope? Is that a problem?
Yeah, it's a problem.
Okay, what's the problem?
Because you have to report those things to your government agency. If you're talking about SSI or Medicaid, you have to report those sorts of change in status. Well, technically, that's fraud.
Yeah, I guess it is. Which is a felony.
Yeah.
Yeah.
It's the F word that we don't like to use.
Here. Yeah, that's our F word. Is felony.
That is our F word. And so certainly your legal counsel wouldn't be part of that. But if you're contemplating that yourself, you're like, how are they ever going to know? I'm just going to take this money and I'm going to put it in a backpack and I'm going to put it in the closet and no one's ever going to know I have it. Well, maybe. But you don't want to risk the consequences of that. Most people don't like to do what's morally wrong anyway.
That's right. Right.
So what can we really do for those people? There are different types of trusts where we're talking about a D4A trust. That's a self-settled trust. Maybe we're talking about a pool trust where they could fund the account themselves. Depends on the amount of money that we're talking about. It depends on whether or not there's someone that would serve as a trustee for them, because this is one of those instances where they could not be their own trustee, and they would have to rely on a third party. Ordinarily, attorneys we're not going to be the trustee for someone, and they need to know that going in, and probably their accountant's not either. So,
and sometimes it's not a bad idea. Maybe for a small amount of money, you can do maybe it's $25,000. You can do something.
Yeah.
You know, maybe you have a child or other family member who can be a trustee because it's not that big of a deal.
Well, you don't want to get into paying a third-party trustee.
That's the whole point. Because then that can be expensive.
Some large trust companies here that do great work in administering trusts, but those are for your $1 $2 million plus trust usually.
Right. So what about ABLE accounts? ABLE.
ABLE accounts are sort of a unique little product, and they're a very nice step forward in allowing someone with disability but still has some function that they can administer their own trust. There are limits as to who can have an ABLE account. It's a little more restrictive than a regular special needs trust. Limits on how that money's used, limits on how much money you can invest total, limits on how much money you can invest per year. But it could be something for small amounts of money. But it could be a nice alternative for small amounts of money that a person that has some functional abilities, they could be in control of their own money.
Right.
So it's something to be considered. Why is it important to have an estate plan, especially if you're an unsupported elder?
if you're an unsupported elder, and that's our term, we don't like to use the term orphan, elder
Right.
orphan. We think, because the point is you can have a lot of friends, but it's really about if an older person is unsupported.
Right.
Who's going to take care of me if I get old and and maybe start having decline or whatnot. So those people, that group, really does need some sort of estate plan. Is there a family a friend? Is there a public agency? Is there an attorney or CPA? It's all about, for the unsupported elders, is a lot of them have money, but what they don't have is they don't have people that can help them.
Yes, they may be single,
Right.
widowed, no children, no close family members.
Right.
Anyway, we probably need to wrap up.
We do. All right. So, well, up next we will be speaking to. I think it's about research trials, right?
Yeah,
We're doing research trials. So stay with us. We'll be right back.
All right.